if you want Sarah to make an introduction on behalf of OUP.
Okay, yeah, hello. So I'm Sarah Harris, the Managing Editor of the Journal of IP Law and Practice, and welcome to this, our 5th webinar. Today, Stefano Barazza will host a discussion on German and Chinese patent law with an expert panel from WilmerHale. A roundup article on China has been published, and this will be followed by a roundup on German patent law decisions, and both will be freely available on the website for a limited time. As I've said before, if anyone watching is feeling encouraged to make a submission to the journal, please do get in touch via the website. Thank you, Stefano and the panel. We very much appreciate your time and insights.
Thank you, Sarah. Thank you very much. So let me first of all introduce our fantastic panel today, which for some strange reason has disappeared from my Zoom, so I'll have to look at them in the gallery view. But we have Vanessa Wettner, Dr. Vanessa Wettner, who is a partner at WilmerHale in Frankfurt. She's an expert in civil and capital markets dispute, but I think IP and competition law have quite a special role in her practice as well. So we're very, very fortunate to have Vanessa on board today. Next to Vanessa, even on my Zoom panel, Dr. Harald Frey, who is an associate also in the Frankfurt office of WilmerHale, and again, an expert in intellectual property, patents, plant varieties, and I would say across all the field of IP. And finally, we have Kenneth Zhou, who is a partner at WilmerHale in the Beijing office, joining us today with hopefully a stable connection, but it seems to be working well for now. He's the author of several books on business law and competition law in China. He is one of the governors of the American Chamber of Commerce in China as well. So we're very, very happy to have all three of you on board. Before I give some information in the webinar, let me start by thanking you. As Sarah mentioned, for the participants who may not be aware of this, Harald, Vanessa, and Kenneth have written 2 patent roundups for JIPLP, one on China and one on Germany. They've all been edited and gone through production, so they should be available online very, very soon, and they will be made available for free by OUP for a certain period of time. So as soon as that will happen, I will circulate the links to their articles to all the attendees today so that you can also read the articles that they are going to talk about. Let me give you, sorry, I'm looking at the chat where I see some activity, but it's difficult to keep an eye on both things. So let me give you just some information about how we're going to run the webinar. We're going to split it essentially into 2 sessions. We will start with Vanessa and Harald giving us an overview of the German patent law decisions in 2019 and what sort of developments have happened in the last year, and also what is the outlook, of course, going forward. And we will use the second half an hour of the webinar for a review of Chinese patent law cases and a little bit of review of also the new Chinese legislation that is relevant to patent law, which Kenneth will provide to us. The speakers have provided 2 fantastic set of slides that I'm going to share very soon in the chat as soon as I finish this introduction. I'm also going to make a link to the files available as well in the chat for those of you who might have trouble accessing the files in the chat, which is what happened last week. In general, I will keep an eye on the chat. I think Eleanor is also keen to keep an eye on the chat for any sort of IT issues that you might have. So if you need any form of support during the webinar, just drop us a line there. You can also use the chat for any questions that you might have for the speakers or any comments. And if we indeed have time at the end of the webinar, I will pick a selection of those questions for the speakers. If we do not have time, which might happen since there's a lot to discuss in 1 hour, we can always save the chat, and you can always get in touch with the authors of the roundups, with the speakers today later on if you have any questions for them. Or you can, as Sarah suggested, you can turn those questions into a little bit of research and maybe an article. At the end, these webinars are meant, of course, to inform and discuss in a period that is challenging for all of us. But hopefully they can also provide some food for thought and encourage some of you who are viewing this webinar today to write a little bit on developments in patent law, as Vanessa, Harald, and Kenneth have done. A final warning before I let the virtual floor, to our speakers today. Final warning is that we are recording this webinar, so I please ask all of you to keep your microphones and cameras switched off, as that makes it possible then for us to publish this on YouTube without seeking the consent of each and all of you, but also because that allows the speakers to appear fully on the screens more easily. So without further ado, thank you so much, Vanessa, Harald, and Kenneth, for joining us today, and I leave the floor to Vanessa and Harald for our first part of the webinar.
Thank you very much, Stefano, and also Sarah for that introduction. We are very happy to give you today a short overview on the most important cases of the Federal Supreme Court in German patent law in the year 2019, even though 2020 appears to be also very promising with the decision of the JIPLP case to be issued shortly, but today we will focus on 2019. I will present 3 cases. 2 will deal with the inventive step, and the third one, a very interesting case with compulsory license under German patent law. As an introduction, as you may all know, the German patent court, as probably most patent codes in Europe, spells out very generally that patents shall be granted for any inventions in all fields of technology, provided that they are new, involve an inventive step, and are susceptible of industrial applications. And a lot of the case law of the Supreme Court obviously deals with the question of inventive step. In the case I first want to discuss with you, the defendant was the owner of a patent covering a method for bitrate reduction in the coding of a signal which is used in image or video processing. And in that case, the plaintiff argued, it's an invalidity case, obviously, that the technical method of defendant's patent had already been disclosed in one specific part of a US patent. And apparently a plaintiff applied for invalidity of the patent, and the Federal Patent Court followed its argumentation. It declared the patent invalid for lack of inventive step because it took the view that the last paragraph in said US patent had already provided an alternative to the method, which was then later on described and disclosed in defendant's patent. Not surprisingly, defendant appealed that decision and was also partly successful. The factual details are not as interesting as the general statements and principles the Federal Supreme Court set out, which will also be applicable to the general interpretation of patent publications. So first of all, the Federal Supreme Court ruled out that individual paragraphs of a patent must not be taken out of context. And it took the view that in this context, the Federal Patent Court wrongfully only considered the one specific part of the US patent in isolation and did not consider the entire context of the publication in order to decide whether inventive step was given or not. And the Federal Supreme Court also explained why it is so important to consider the entire context of the publication, because with the approach the Federal Patent Court had taken, that would create a risk of misinterpretations, because frequently patents contain, of course in varying degrees of detail, information on possible modifications of the described technical method. in particular, for example, the description of examples of an execution. And if such part is only examined in isolation to determine whether it contains elements of the technical method of the patent in dispute, this would actually mean that the context of the earlier invention is replaced by the context of the later invention. And actually, such an interpretation would take a retrospective approach, which is apparently not the right approach. Therefore, it is important that each modification is not looked at in isolation, but always in connection with the entire context of the patent publication. And if the references to such modifications are not concrete and precise in the patent publication, then it cannot be assumed that a skilled person was able to conclude what specific modifications are apparent from the patent. So the decision as such is very lean and very straightforward and short, but it is important to the extent that the Federal Supreme Court sets up general principles as to the interpretation of patent publications. The second case I wanted to discuss is also a case on the inventive step requirement. In that regard, Section 4 of the German Patent Code rules out that a patent can only be granted if the invention is not obvious to a person skilled in the art. And again, this is of course a question where we have a broad variety of case law of the Federal Supreme Court, and the Federal Supreme Court already established a general principle according to which it always has to be reviewed whether a certain invention is obvious to the skilled person of the art. And that question always depends on whether there is a reasonable expectation of success for the skilled person to pursue a certain approach. And this criterion has particularly been developed by the Federal Supreme Court in cases involving chemical patents. And it has been repeatedly used, the principles I'm going to set out by the German courts, Supreme Court, but also the instance courts, in order to make the final decision on whether there is a necessary inventive step or not. By the way, the guidelines the Federal Supreme Court developed are also very similar to the approach the Board of Appeals of the European Patent Office. In this new case, which was decided in April 2019, the defendant was the owner of a patent for the use of fulvestrant, an estrogen suppressant in a specific formulation against breast cancer. And the mechanism of action of fulvestrant was well known, so that was not at dispute. But the fulvestrant formulation as such was problematic in terms of its formulation, as it generally showed a very low water solubility. So there was still a problem evident which needed to be resolved. Again, an invalidity proceeding was initiated, and the Federal Supreme Court further concretized in these proceedings the requirements for a reasonable expectation of success. First of all, he ruled out that the decision cannot be taken on general terms, but always needs to be determined on a case-by-case basis. The Supreme Court then went on to develop certain criteria which have to be taken into account when determining the reasonable expectation of success in a specific case. The first criterion is the specific field in question. So it always depends in which area, of course, the patent has been published. And for that specific area, it then has to be reviewed, kind of a second criteria, whether the professionals had a sufficient incentive to adopt or pursue a particular approach. As a third step, it then has to be reviewed whether that particular approach requires which and what scope of efforts that particular approach requires in order to be pursued. And whether there are, and this is the fourth criteria, whether there are certain alternatives which can be considered. And with respect to these alternatives, like the fifth criterion, it also has to be reviewed whether the alternatives have advantages and what kind of disadvantages these alternatives have. So with these 5 criterions, the Supreme Court lays the basis for the determination of the question whether a reasonable expectation of success is given in a specific case. And in the case which the court decided in April 2019, he came to the conclusion that there was no inventive step given, and for that reason, the patent was declared invalid. Interestingly, there was a clinical study described in the patent publication. So there was already a concrete information given in the patent publication, and it also described that the fulvestrant solution was successfully clinically tested in that study. However, the Supreme Court emphasized that the study did not disclose the exact formulation of the solution, particularly the components of the formulation. And that exactly was the reason why the court came to the conclusion that a skilled person would have reasons to further look into that and would have further investigated whether specific formulations are already known or not. And this would then, in that specific case, would have led him to find another study which eventually specified a certain formulation that comprises all components mentioned in the defendant's patent. And for that reason, because the information which was already given in the patent publication, the court finally came to the decision that the inventive step was not given because the skilled person had information with which it could develop and further investigated these specific formulations. As a side note, the Supreme Court also emphasized that the mere fact that the study, which was referred to in the patent publication, also indicated certain side effects and downsides would not be a reason in order to deny inventive step, because still, even though negative side effects had been mentioned in that study, still the court thinks that a skilled person would take this fact as a reason in order to initiate further research and then finally find the other study which ultimately disclosed the specific formulation. The Supreme Court also emphasized, and this is, I think, good to know as a general guideline, that particularly with respect to the development of medical substances for human use, it is usually not decisive whether an expert can expect to find a result suitable for a clinical trial only. But we have to go one step before. It is sufficient for a reasonable expectation of success that from the patent publication, it can already result the possibility of verifying the efficacy and tolerability of a formulation in an animal experiment, and that this set out would then give a sufficient predictive value for the therapeutic use in humans. So we do not have to be sure that a clinical trial is already possible, but the first step, the animal experiment, if that is possible and if that follows from the patent publication, that is already sufficient in order to assume a reasonable expectation of success. So I think this, as the first decision, also this second decision sets out very nicely very general principles in order to determine inventive step. As I said, the third case, it's a totally different scenario. It's also deals with pharmaceuticals, but it is interesting to the extent that it deals with compulsory licenses under patent law. Over the last years, compulsory licenses have typically been discussed in the field of antitrust law, so the combination of antitrust law and patent law, but this is not the case I am talking about today. The case I'm referring to deals with Section 24 of the German patent code. It's a provision which just until recently has not been dealt with very regularly. Section 24 covers the requirements for a non-exclusive compulsory license and makes clear that this can only be obtained if two conditions are met. Firstly, within a reasonable period of time, the license seeker has successfully attempted to obtain permission from the patent holder to use the invention on reasonable commercial terms and conditions. And second, equally important, a public interest calls for the grant of a compulsory license. So these are the two requirements which are set out in the law. And as I said at the beginning, up until 2017, there were very few decisions on compulsory licenses by the Federal Supreme Court. But over the last 3 years, the Supreme Court had issued 5 decisions on this specific provisions. And the most recent decision is from June 2019. The factual setup was as follows. The plaintiffs market the medicinal product Proluent in Germany, which contains the active substance, I hope I do not misspell it, alirocumab. And alirocumab is an active substance which inhibits the PCSK9 protein and thereby causes a reduction in the LDL cholesterol level in the blood, which is, as you know, one of the main risk factors for atherosclerosis. The defendant owns a patent in the same area. The defendant's patent covers antigen binding protein against this specific protein, the PCSK9 protein. And both parties had been in dispute over quite some time. Ultimately, the plaintiffs filed an action for the grant of a compulsory license back in July 2018. Typically, these actions have to be filed in the first instance with the patent court, and then the appeal proceedings are being dealt with by the Supreme Court. In this case, the patent court had rejected the request of the plaintiff, and the German Supreme Court confirmed their rejection and took the decision again as a matter in order to further develop on the requirement of compulsory licenses under German patent law. And it said that both requirements, the two requirements which I referred to at the beginning, sufficient efforts and public interest, both requirements were not given in the case at hand. And in the Supreme Court further developed, particularly with respect to the sufficient efforts, that in the case the plaintiffs have not made sufficient efforts during a reasonable period of time. Usually this also has to be decided, of course, on a case-to-case basis. And in the case in dispute, the Supreme Court ruled that plaintiffs had only shortly before they filed their action expressed their interest in obtaining a license, and they only offered a very low license fee. Actually, they only offered around 2% as a license fee. They also did not respond to the defendant's reply letter. And in this regard, the Supreme Court also emphasized that it was important that the defendant's reply letter did not only refuse to grant a license per se. They made the general statement that they would not be generally willing to grant such a license, but they also said that if specific circumstances are given, they could exceptionally consider to take such a license. And to that letter, the plaintiffs did not even respond. And for that reason, the Supreme Court came to the conclusion that the efforts plaintiffs made were not sufficient in time, but also not sufficient in content. And even though the Federal Supreme Court could have stopped at the first requirement, it also dealt with the second requirement, the public interest requirement. And again, it denied this requirement. It initially ruled that the requirements for demonstrating public interest are generally very high. It said that the idea is that the public interests can only be affected if there are special circumstances that outweigh the exclusive right of the patent owner. And the Supreme Court made clear that in the case at hand, the grant of a compulsory license was may be given if significant results of a clinical study in accordance with the principles of statistics demonstrate that the active substance of the medicinal product has a therapeutic characteristics for the treatment, and this is very important, of serious diseases which are not or not to the same extent demonstrated for other products available on the market. In particular, this may be the case if it can be demonstrated that the treatment reduces the risk of death of a patient, or if such superior characteristics are otherwise demonstrated. And in the case at hand, the Supreme Court made clear that these requirements were not given. Both products are in the same area, are offered in the same area. They both showed a significant reduction of the cholesterol level. And the studies which plaintiff had presented, even though they showed that fewer patents in plaintiff's product suffered a coronary heart disease or died due to cardiovascular diseases than in other control groups, the court did not consider these study results as sufficient, with the mere explanation that the numbers which were shown in the studies were not statistically significant. So the case shows which specific requirements have to be given for a compulsory license under German patent law. And the case also shows that if such a license is being requested, it always has to be documented in detail how the license negotiations have been taken up, what kind of offers have been made. It's of course important to document all that in writing. And the license seeker must also at all times demonstrate that he is willing to take a license at appropriate terms. And if these principles cannot be shown by the correspondence which has been exchanged and too much time has been taken, then the requirements for a compulsory license are not given. I think that the case also still leaves some unclarities. For example, it is unclear whether this section 24, which governs the compulsory license, whether that has any effect on infringement proceedings. If, for example, the prerequisites for a compulsory license are given, but the license has not yet been negotiated, would that cause the infringement proceedings to be stayed, or would they run in parallel until a license has been negotiated? So these questions still remain open, but the fact that the Supreme Court has dealt with this topic in the last 3 years for 5 times indicates that more cases will very likely come to discuss compulsory licenses in German patent law. So these are the 3 cases I was going to present. Thank you very much, and I'm happy to hand over to Harald or Stefano. I am not sure.
Yeah, no, we can hand over to Harald for the other 3 cases. I'll just tell Harald to keep an eye on the clock. That's the only thing. Of course, it's very interesting. These first 3 cases, I think, are extremely interesting, especially because there's a clarity coming from the Federal Supreme Court in Germany, which is always welcome in patent law. And even if gaps still remain, I think, for example, on reasonable expectation of success, it's really, really nice to see a lot of detailed steps, which actually help us understand exactly that fine line between a roadblock which actually prevents the inventive step from happening and the roadblock that instead creates the requirements for the inventive step. So very interesting fine detail, but Harald, I'll just mention to keep an eye on the clock just to make sure that we stay within a reasonable time for the overall time.
Yes.
Thank you very much, Stefano and Vanessa. I'll try to hurry up a bit, but I still would like to cover 3 more topics. The first case I would like to talk about concerns the unjust enrichment claim after statutory limitation in German law. And just to give some background, under German law, the statutory limitation period for damage claim in patent law is determined by reference to the general principles of statutory limitation in the German Civil Code. And basically this means that the patent law damage claim has in principle a standard statutory limitation of 3 years. The relevant provision is here section 141 of the German patent code, the code that makes reference to the general principles of the German Civil Code. However, There is also a 10-year statutory limitation period for unjust enrichment claims, and I believe these unjust enrichment claims are really more something unique in the civil law jurisdiction, and I believe there's not so present in common law jurisdictions. So basically, Section 141 of the Patent Code also states that where the person is obliged, the person obliged has obtained something as a consequence of an infringement at the expense of the entitled person, then Section 852 of the German Civil Code shall apply, in the Section 852 of the German Civil Code basically is the unjust enrichment claim, and provides that even if a person obtains something at the cost of the injured person, then even after the claim for compensation for damages has reached the statutory limitation, the person is still obliged to make a restitution under the provisions on the unjust enrichment. So in the case, the German Federal Supreme Court had to decide the plaintiff asserted claims for the infringement of a patent on a power supply device. And then the defendant argued that the plaintiff would not be entitled to claim damages for the period after the statutory limitation. So the claim, it was argued, partly exceeded the statutory limitation of 3 years. However, the Higher Regional Court of Karlsruhe, which was the Court of Appeal here, held that the statutory limitation for the patent law damage claim was indeed exceeded, or indeed it exceeded the 3 years, but it accepted a claim for damages based on the provision I just mentioned, according to the law on unjust enrichment. Now, the Federal Supreme Court confirmed this decision of the Higher Regional Court of Karlsruhe, basically meaning that the plaintiff was awarded damages even after the statutory limitation has been exceeded of the 3 years here. The court argued that the patent owner may reclaim any enrichment the defendant has obtained as a consequence of the infringement at the expense of the entitled person, and that enrichment also includes the unlicensed use of the patent and the profit which the infringer has obtained through this unlicensed use of the patent, so the patent infringement. So this infringement, and this is basically the general principle of unjust enrichment in German law, must then be returned by the infringer to the patent owner, even after the patent law claim on damages has exceeded the statutory limitation. The Federal Supreme Court also stated or reasoned that here the purpose of this claim is really to prevent the infringer from keeping unlawful advantages that he obtained as a result of the infringement, and thus to the detriment of the patent owner. So the idea is really that the person has obtained something at the expense of the other party, and this includes damages. And these damages can be calculated based on the license analogy approach, meaning that the other party has to pay a reasonable license fee. But the scope of this claim is really not restricted to this method, but instead the patent owner may also claim the restitution of the profit of the infringer. And this is important because the jurisprudence has been rather restrictive in this respect. So that some German courts used to refuse to grant such broader damage claim involving the profit of the infringer, but now the patent owner can really consider to sue for damages, including the infringer's profit, even after the 3 years of the statutory limitation have been exceeded. So as a result of this decision, I think the statutory limitation in patent law, the 3 years, will likely lose some of the relevance, but this also strengthens the position of the patent owner, since the restitution claimed based on unjust enrichment is still enforceable beyond statutory term limitation for a time of 10 years. So turning to the second case, this case concerned the requirement of sufficient disclosure, and Section 34 of the German patent code states that the application for a patent shall disclose the invention in a manner sufficiently clear and complete so that the skilled person in the art can carry it out. And this is also stated in the European Patent Convention in Article 83, saying that the European patent application shall disclose the invention in a manner sufficiently clear and complete for it to be carried out by the person skilled in the art. If this requirement of sufficient disclosure is not met, the patent shall be revoked or it can be challenged. So in this case, the Federal Supreme Court had to decide, actually these are two cases, but they are closely interlinked, as we will see. In this case, the defendant owned a patent concerning a chemical composition. And in the first case, the Supreme Court had to decide, the patent specified that the surface of the specific surface of the chemical composition had to contain a certain minimum amount. So basically specifying that the composition should contain at least, and then it specified a certain amount. So the at least is the important part here. And in the second case, the patent described that the chemical composition should require certain components within a certain value range. So basically describing that it should contain at least, and then specifying the amount, but at most, and then specifying another amount. So the Federal Supreme Court decided in the first case that in this specific case, the requirement of sufficient disclosure was not met, basically because there is an open-ended range in one direction. However, in this second case, the Supreme Court confirmed the decision of the Court of Appeal, meaning that the requirement of sufficient disclosure was met. In the first case, however, it's important to stress that the German Supreme Court said that this specification of the patent that just goes in one direction does not per se lead to an insufficient disclosure. Rather, in such cases, it's decisive whether the open range shows a new generalized teaching enabling the skilled person to search for further possibilities for improvements. And this requirement was not met in this specific case because it basically involved a chemical composition that was pretty known already by the time. So the description of the open range here in the first case with the at least requirement showed no new generalized teaching. It did not, for example, show that a new class of composition could be found. Rather, the different components were already known, and this did not involve a new generalized teaching. In the second case, the description of the value range, specifying with the words at least and at most, the court said that this can be sufficient if the method of measurement to determine these values is available to the person skilled in the art. So the person, it's decisive if the person skilled in the art can reliably determine the relevant components that need to be applied here to achieve that composition. So it's irrelevant if the person has to rely on general technical knowledge. The method of measurement to determine the relevant values to achieve such composition must only be available to a skilled person. And the patent must not even describe all relevant parameters of the measurement to determine this specific distribution in the composition in this case. it's sufficient if the skilled person generally knows how to measure and determine the relevant values in this case. The final case I would like to talk about is about the so-called prior use right in German law. As to the background, of course, we all know that the patent law grants an exclusive right to the patent owner, so he is entitled to exclude all others from using his invention. However, there is a certain exception in German law in section 12 of the German Patent Code, stating that the patent shall have no effect in respect of a person who, at the time the application was filed, had already begun to use the invention or made necessary arrangements for doing so. That person shall then be entitled to use the invention for the needs of his own business. So the German case law on this prior use right has traditionally been rather restrictive. So the continued use of the invention is really limited to the business of the prior user, and also restricted in scope, as it just may not exceed the use of the prior use of the invention. And any modification done in this invention by the prior user must not deepen the interference that we already have here with the scope of the patent right. Of course, there is also often an evidence problem to this, because the defendant would have to show and prove that his uses actually fall within the scope of the prior use right. So he would have to show, and in case of dispute also prove, that the use that he actually made a prior use of the invention before the patent came into force. In the case the German Supreme Court had to decide, the plaintiff owned a patent relating to certain protective enclosures for radio equipment, and you can actually see the invention if you check the PowerPoint presentation that were sent out. It's a so-called run dome, and it's basically an outer shell that protects against certain environmental influences, but at the same time it absorbs as little electromagnetic radiation as possible. So prior to filing of the patent, the defendant only supplied to the customer all necessary components for the construction of this run dome. But then the defendant also started delivering the complete device after the patent had been granted. And of course, here the defendant tried to defend himself by just arguing he was making use of the prior use right. The higher regional court of Düsseldorf rejected the plaintiff's claim and decided that the defendant could actually rely on his prior use right. The German Supreme Court essentially confirmed this decision, meaning that the defendant exercised his prior use right. The court argued that the idea of the prior use right is that the patent owner should not be able to exclude anyone from the use of the invention who has previously used the protected technical method or made specific arrangement for such use. So the purpose is really to avoid an undue destruction of values created in a legally unobjectable manner before patent protection has been granted. However, the scope of the prior use right may be exceeded if the invention is modified in such a way that it leads to an additional benefit which was not present in the prior use. But here the defendant could rely on his prior use right because, and this is the argument of the court, otherwise the defendant would basically not have been able to make use of his right in any economically reasonable manner. The fact that here the defendant initially only delivered individual part of the device did not change this finding, as the defendant delivered all relevant parts that were necessary to be combined in a specific way to complete the device. Thus, it did not matter whether the defendant himself or a third party actually combined the single parts of the device and then built the entire device. The fact that the defendant eventually decided to build the entire device himself at a later stage was therefore still covered by the prior use right. And the argument again here is that this is the only way you could make use of your prior use right in a really technically and economically meaningful way. So this decision essentially, I think, strengthens the position of businesses that make use of the prior use right, that started by really manufacturing just and supplying certain components, but then ultimately switched to manufacturing the complete device themselves. That's all from my side. Thank you very much. I'll hand over to you, Stefano.
Thank you very much, Harald and Vanessa. I think this is extremely interesting. There's a lot of fine-tuning essentially happening here, I think. And for any participants who was also online last week, clear parallels, at least to some of the developments in England and Wales as well. I'm thinking about, for example, numerical ranges and interpretation, maybe looking at the same issue from different sides, right? One concerning the claims, concerning the validity and potentially infringement, and everything seems to be connected also across jurisdiction. So this serves me well in introducing Kenneth's part, because I think in China we will see something slightly different in a way. We will see legislative developments, and there's also a broader sort of issue in terms of relationship between, for example, China and the US. And all of this interplays in a way in the developments of patent law in China. So Kenneth, over to you. We are running late and I apologize with all the participants, but there's so much to discuss, and hopefully for those of you who have to drop out, you'll be able to catch up with the YouTube recording just in case. Kenneth,
Sure, thank you, Stefano. I'm glad to be here, join this webinar. I understand now it's about lunchtime in the UK, and so I will try to make it quick. I'm a partner of WilmerHale in the WilmerHale's transactional and corporate department. We advise clients, international clients doing business in China with respect to corporate investment, IP issues, as well as compliance. We also advise Chinese clients with respect to their investment outside China. So, China, as other key jurisdictions, its patent legal regime is also a pretty complex and rapidly evolving regime. There's no way for my presentation, to cover all the key issues, but just to give you a quick overview in terms of some of the most important developments in the Chinese patent law regime, as well as the litigations. So in China, in 2019, Chinese government continues to strengthen the protection of patent and other intellectual property rights in China. And the improved environment of patent protection is to some extent sort of evidenced by a growing number of foreign patent applications in China. According to the report of China National Intellectual Property Administration, from January to July last year, foreign applicants filed about 92,000 invention patents in China, with a year-to-year growth of about 8.3% compared to the year before. And also according to some surveys conducted by leading non-government organizations, including the US-China Business Council, American Chamber of Commerce, and others, the survey reports show that the majority of foreign companies, member companies in China, held the view that China has been enhancing its IP protection in recent years. But of course, there are still many issues, and China's patent legal regime is still sort of catching up. It's evolves very rapidly, and there are many issues remain. So in this connection, I would like to briefly mention the US-China trade friction and it has been going on almost for now it's close to 2 years. The trade dispute initially started in 2018, 2017, 2018, and it continued in 2019. And in December 2019, after almost 17 months of trade negotiation, the US and the Chinese government eventually reached an interim phase 1 agreement to address the trade issues. And this agreement, phase 1 agreement, represents a partial truce in the trade dispute between US and China. US government agreed to relax some tariffs imposed on Chinese imports in exchange for commitments to purchase Chinese government commitments to purchase US goods, and to address some of the long-standing issues, including IP concerns and issues faced by US companies and other foreign companies doing business in China. Based on the US US Trade Representatives Phase 1 fact sheet, the Phase 1 agreement in terms of IP between the two countries address numerous long-standing concerns in the area of trade secrets, pharmaceutical-related intellectual property, trademark and enforcement against pirate and counterfeit goods, and set out binding and enforceable obligations against unfair technology transfer, the practice of forcing oppression foreign companies to transfer their technologies to Chinese companies as a condition for obtaining market access, administrative approvals, or receiving advantages from governments. And also a more transparent, fairness, and due process will be established in administrative proceedings in terms of technology licensing and in terms of technology transfer. So in response to the US-China Phase 1 deal, and also as Chinese government has repeatedly mentioned on a number of occasions, despite the US-China trade friction, China is determined to continue to open up and continue to strengthen the protection of patents and intellectual property rights of foreign companies doing business in China. So in this connection, the Chinese government has made a range of new legislations in terms of Chinese domestic law. One of the key new legislation is the 4th Amendment to the Chinese patent law. This is the 4th amendment of the patent law since it was first enacted back in 1984. So there are a number of key improvements, including under the new amendment, including emphasis on the principle of good faith in patent filings and applications of patent rights, significantly increase damages and fines for willful patent infringement and counterfeit activity. For example, the damages, the discretionary compensation that can be imposed by the courts in cases where patent holders have difficulties to prove damages is now increased from the range of RMB 10,000 to RMB 1 million to a range of RMB 100,000 to RMB 5 million. And also it reduced the burden of proof on patent holders in patent infringement litigations. It makes clear that the entities that supply raw materials, components, work in process, equipment, and services to patent infringers, knowing, meaning sort of actual knowledge or constructive knowledge, knowing that patent infringers will use such goods or services to produce infringing products, will also be subject to joint liability for patent infringement. And there are a number of other key improvements. I'm not going to spend more time going through these, but the 4th Amendment to the patent law is very clear in terms of, it is intended to encourage innovation and to further strengthen the protection and the enforcement of patent rights as well as other IP rights. In addition to the patent law amendment, there are also new laws and regulations promulgated by the Chinese government One of the key new law is the new foreign investment law. Of course, the foreign investment law talking about a lot of investment related issues, but the foreign investment, one key respect of the foreign investment law is it also emphasizes on the protection of intellectual property rights of foreign investors in China, and the mandates that all technological cooperation between foreign and Chinese companies be carried out on the principle of, voluntariness, commercial norms, and free negotiation. And shall not be any forced technology transfer. And in addition to foreign investment law, there are also a number of amendments of the existing regulations. For example, the technology import and export regulations, the Chinese anti-unfair competition law, which basically, among others, it also, to strengthen the protection of non-patent trade secrets and the commercial secrets of companies in China. With that, it's not that the changes are not just happening on the level of legislations. It also, the Chinese government and the court systems have been undergoing a number of restructuring. For example, the Patent Re-examination Board, which is responsible for patent re-examination and invalidation reviews, and China's Trademark Office were both incorporated into the China State Intellectual Property Office, which is called JIPLP, which really created China's first joint patent and the trademark authority. Of course, JIPLP was subsequently renamed as China National Intellectual Property Administration. In terms of court system, the judicial system in China, as you probably know already, in the past few years, there are a number of specialized IP courts established in China, in big cities in China like Shanghai, Beijing, Guangzhou, and there are also including other cities. And in addition to these specialized IP courts in different cities, in different provinces in China, the Supreme People's Court also established a special IP tribunal to focus on complicated IP, including patent cases. And the IP tribunal will hear appeals related to invention, patents, trade secrets, antitrust claims, computer software, information communication designs, and the new patent varieties. The Supreme People's Court in 2019 reviewed about 3,845 intellectual property cases, including about 1,931 patent cases. So patent case increases from 43% to roughly 50% of all IP cases in 2019. With that, I'm gonna review quickly go through the 5 cases, patent cases in China. As I said, Chinese patent legal regime is still evolving rapidly. There's no way to capture all the important cases. So the purpose of my presentation is just to give you a very high level overview in terms of some of the most important patent cases happening in China back in 2019. So the first case is the Wuxi Guomei case versus Changshu Lingzhi. Both companies are Chinese domestic companies, but this case was listed as one of the model cases published by the Supreme People's Court in China back in 2019. So this case is relating to the assessment of damages in patent infringement cases. So it's a long story, but to keep it short, the patent infringement was confirmed by the court in this case, but the dispute was really on how to determine the damages. And the trial court, only award a damage of 1 million RMB, but that decision was overruled by the Supreme People's Court. The Supreme People's Court sort of like increased the damages almost 10 times compared to the decision of the trial court. So basically in this case, in China, under the patent law, actual damages suffered by patent holder are calculated in the following order. By actual damages or losses suffered by patent holder, to the extent that such damages or losses can be proven, profits received by patent infringer from the patent infringement, references to the licensing fee of the patent in question or similar patents, and statutory compensation. It's basically, the statutory compensation refers to discretionary compensation determining the courts, in case, the plaintiff fails to prove its damages. And in China, sometimes it's very difficult I guess it's not only China, but also in some other, in many other key jurisdictions, it's very difficult for the plaintiff to prove damages, by providing sufficient, evidence. According to a report issued by the China National Intellectual Property Office, about only 2.4% of all patent infringement cases where the courts awarded damages in an amount greater than RMB 5 million. So you can tell that, the patent holders in China are often not adequately compensated, even though an infringement is found. But in this case, the Supreme People's Court, they apply a new sort of methodology in terms of calculating damages. You can find the details in the article. So I'm not gonna spend more time in this connection. The second case is this case, Jaguar Land Rover versus Jialing Automotive. So this case is relating to copycatting design patent. In this case, why this case is important? Because this is perhaps one of the first cases in the automotive industry in China, where the Chinese court determined that a domestic automaker's design patent design infringed a foreign branded design. And the significance of this case is really the approach taken by the Supreme People's Court in terms of the technical assessment. So during the technical assessment, the Supreme People's Court basically focused its analysis and assessment on overall design appearance of a vehicle, and then consider the roles and the impacts of specific design differences in overall design. In determining whether specific design differences can distinguish the overall design of a vehicle from others, the Supreme People's Court said one needs to consider both the technical value carried by such differences, but also more importantly, the ability of ordinary consumers to perceive and understand such differences. So this case also reflects China's effort to implement the commitments under the new foreign investment law, as well as the phase one deal between US and China to improve protection of patents and other intellectual property rights of foreign companies doing business in China. So the next case is Value Systems versus Sharman Lucas Automotive. This case was the first case handled by the Supreme People's Court IP Tribunal since its establishment back in early 1929. So Value is a French automotive parts maker, and which claimed that this Chinese automotive manufacturer had infringed its design patents relating to windshield wiper devices for motor vehicles. So the significance of this case is really, in this case, the trial court, which is the Shanghai IP court, made a partial decision confirming the infringement and granted a permanent injunction pending the decision to determine damages. And in litigations in China, usually all these issues are going to be all handled all together. But sometimes, because of the complexity associated with determining damages, the case can take a long time to conclude. But now, because the new approach taken by the trial court, which was later on also confirmed by the Supreme People's Court, the party, especially the plaintiff, can receive the protection of a permanent injunction very quickly, even pending the decision on the damages. So this is also perhaps the first time where the court made a partial judgment on the substantive merits of a patent infringement case, pending determination on damages. The next case is the Xiamen Power versus LG Electronics. The significance of this case is this is the first case consolidating the patent validity and infringement disputes into one proceeding. China has been adopting this bifurcated system for infringement and invalidation proceedings, where the courts rule on infringement cases and the patent re-examination board decides on patent invalidation cases. Although one can always appeal the patent re-examination board's decision before the courts hearing appeals relating to patent invalidation are often different in practice from the courts hearing the patent infringement cases, because the former administrative court cases and the latter are civil cases. So this bifurcated system has wasted a lot of time and created a lot uncertainties and discrepancies for the same patent lawsuit. So the Supreme People's Court took an important step in this case to reduce the discrepancies resulting from China's bifurcated infringement and invalidation proceedings. And by consolidating the two proceedings into one, in this particular case, the Supreme People's Court was able to do a more comprehensive and a streamlined review, which also significantly enhanced efficiency. I guess the last case is this patent extortion case. This is the first case. This is a case happening in Shanghai, and where an individual patent owner was convicted for patent extortion. The significance of this case is because this is perhaps the first time, patent extortion case where a patentee was criminally charged and convicted in China. So, while China has been strengthening the patent protection in the past decade, abuse of patent rights and using junk patents to coerce others to pay a large amount of fees has become an increasing concern in China. However, these issues, the boundaries of patent coercion, abuse of patent rights, are not clearly defined under the Chinese patent law and the relevant judicial interpretations. So in this case, the Chinese court has, for the first time, established some standards for patent trolling activities that might constitute a crime of extortion, which to some extent became the precedent, a precedent in terms of patent extortion cases in this connection. So, so these are the 5 cases. In terms of a patent protection going forward, it is clear that China plans to continue to improve its IP protection regime in the years to come. However, as you are probably aware, the escalated technology, the escalated trade tension between US and China, especially in the area of high technologies recently. For example, the further ban on the Chinese technology company Huawei by the US government a few days ago, as well as the Chinese government's response in terms of the potential introduction of China's unreliable entity list, which is an equivalent to the US entity list. It's create a lot of challenges and uncertainties with respect to the where China is going to go in terms of its IP protection regime in the years to come. So I guess it's with that I'm happy to conclude my presentation. Of course, if you have any questions, happy to follow up with you after this presentation. Thank you.
Fantastic. Thank you so much, Kenneth. We have just one question from Metka about the foreign investment law. Does the foreign investment law give any private rights to IP holders?
That's a very good question. That's a very good question. And I would say, foreign investment law, probably, as you are already aware, after promulgation of the foreign investment law, China also promulgated some regulations to establish this complaining mechanism for foreign companies doing business in China, so that where foreign companies doing business in China are investing in China, if you have any issues or if you have any complaints, whatever it is, whether it's investment, whether it's funding issues, whether it's the issues with local governments or IP protection, you can always make a complaint to the Chinese government at a central level. And this complaining sort of mechanism was promulgated in associated with the implementation of foreign investment law. Of course, there are many other laws in China, like the patent law, the civil litigation law, civil procedure law, where private companies, including foreign companies in China, always have the right to sue the patent infringers in China. And China just promulgated 2 weeks ago, I think, a very detailed IP action plan, which consisted about 130 measures to be, including new laws and regulations, including new, enforcement actions to be taken in the next 2 years. So of course, with growth in economy, China is paying more and more attention to IP protection, including patent.
Yeah, I think your presentation highlighted this very well, and if anyone that will be able to read your article as soon as it's available for free online and subscribers can already access it, I think they will appreciate the evolution essentially of IP and patent law in China, which is just so broad, if you like, and I think you have presented that extremely well. So let me thank you so much, Kenneth, for your presentation. Vanessa and Harald, you've been fantastic, and I think everyone has truly appreciated all the developments that you have shared with all of us. We have taken a little bit more than an hour, but not too bad. So thank you so much. And on behalf of also of all the participants and also on behalf of OUP. So take care. And for anyone that has further questions and so on, I'm sure that you can also address them to the speakers today. But otherwise, as I said at the beginning, do consider writing on them. It's really interesting and really important to share your thoughts, your comments, your research with all the community in a way, as Vanessa, Harald, and Kenneth have done today. So thank you so much, and keep safe.
Thank you.
Goodbye.
Thank you.
Bye.
Thank you.
Thank you.